Okay, hello everyone. It's lovely to see you this afternoon. I have great pleasure in welcoming Phil to our workshop this afternoon. Phil is a welfare benefits advisor who works with individuals who have suffered brain injuries. And he's with us today to talk through the benefits available to brain tumour survivors and their parents, carers, particularly focusing on the ages of transition. There's going to be opportunities to ask questions throughout the presentation, so please post them using the webinar Q&A function. And I think it's over to you, Phil.
Okay, thank you very much. I'm a welfare benefits advisor with a company called Surviors. I've worked within the benefits system for 29 years. I worked for the Department for Work and Pensions for 22 years, and I've worked for Surviors for the last 7 years doing all kinds of benefit related things with regards to reviewing people's benefit entitlement, appeals, benefit applications, all kinds, anything benefit related I will undertake, whether it's the Department for Work and Pensions, HMRC, local authority, some NHS, but not much. But I will generally deal with anything welfare benefit wise. So let me just see if I can share that screen. There we go. Now, since there was a change of government in 2010, there's been a lot of changes to the benefit systems. They brought in a raft of new legislation aimed at reducing the welfare bill. It started under the Welfare Reform Act and then continued throughout the next decade. Unfortunately, this hit people with disabilities and health conditions in a disproportionate way to other claimants. They introduced something called the Work Capability Assessment that was part of employment support allowance. That was basically to try and get people off sickness benefits and back into work. They introduced personal independence payment as a replacement for disability living allowance. It's a stricter benefit with regards to the eligibility criteria, so it is harder to qualify for. They also removed the work-related activity component within ESA, which meant that people were worse off. At the time, it was just under £30 a week. Under universal credit, they have also removed something called a severe disability premium, which at the moment is worth just shy of £70 a week. So that's a huge loss for people. They've also made 2 changes in the last couple of years for disabled students to make it virtually impossible for them to claim benefits whilst they're studying. They've made various other changes. They've introduced the benefit cap. They've changed council tax benefit to council tax support, which is now a localized scheme. And it's a bit of a postcode lottery of how much support you actually get because it depends upon the local authority. They introduced the bedroom tax, and they've made it much harder for immigrants to claim benefits as well. With the removal of so much funding, benefit support for claimants has reduced significantly over the last 10, 12 years. So I've just listed some useful websites there. Now, a lot of these are charitable organisations. Some of these are just online help support groups. The Child Poverty Action Group, they do a lot of work and a lot of judicial reviews with regards to taking the Department for Work and Pension to tribunal when they think that something is unlawful. The Citizens Advice Bureau, they can give you advice on all kinds of things. They're closely linked with universal credit as well now. Disability Rights UK, again, a very helpful online advice centre. Turn to Us and Entitled To, they offer a lot of online advice with regards to all kinds of benefits, and they also do benefit calculators. So you can actually go online, input your details and find out how much benefit you should be entitled to. The Brain Injury Group, which helps obviously people with brain injuries, and the Child Brain Injury Trust that helps children and their families. So there's a lot of help available, but most of it is online. Some still do appointments, some still do advice over the telephone. The Citizens Advice Bureau, Child Poverty Acting Group, Shelter will do some, but that's mainly housing. So there is some help available, but not as much as there used to be. So as a very quick introduction to some benefits, benefits are divided into 3 groups. There are universal benefits, contribution-based benefits, and means-tested benefits. So very quickly, universal benefits, there's no qualifying criteria. It's not based upon your capital, your income, or your national insurance contributions. Child benefit is for the whole, or for the general part, a non-means tested benefit. Disability living allowance, personal independence payment, and attendance allowance are all disability benefits. You don't need to have made national insurance contributions. They're paid based upon your level of disability. Maternity allowance, obviously paid through an employer, and the carer's allowance as well. So if you have somebody that's caring for somebody for 35 hours a week, providing they don't earn more than £132 net, they can claim carer's allowance. It's not a huge amount of money. It's just shy of £70 a week, but it's there and it's useful. Contribution-based benefits, anyone that's worked and paid national insurance contributions, or they've received benefits and paid national insurance contributions, can claim one of these benefits. Job seekers allowance and employment support allowance, they still exist as contribution-based benefits. So if somebody is working and they've had an injury, a brain injury, they've had to give up work, they can claim employment support allowance on a contributory benefit, and it will be paid for a minimum time. State pension, so national insurance contributions go to our state pensions. Industrial injuries disablement benefit, that's for anyone that's had an injury at work. Incapacity benefit is an old benefit. It was replaced with employment support allowance and any bereavement payments. The means tested benefits, which are the biggie, this is one that, this affects everybody really, but they are means tested in that they will take capital and income into account when they decide how much you're going to receive. Some of these have now been replaced. Income support is replaced for new claims. It does still exist, but only for existing claims. The same for job seekers allowance, the same for employment support allowance. Housing benefit and tax credits, they've all been taken over by universal credit now. So the only benefits that are available for new claims are universal credit, council tax support, and pension credit. So given that there's so many benefits and there's all kinds of legislation and rules regarding entitlement and rules around capital, income, overlapping benefit rules, it can become an absolute minefield. So rather than go through each individual benefit and try and explain what the eligibility criteria for those benefits is, we thought it would be much easier to do some case studies. So we'll look at 4 scenarios and we'll see what help is available in these situations. So the first one, case study 1. So Michael has just turned 16, lives with his parents. Only one parent is employed, earning £28,000 per year, and the property is owned. Michael has some cognitive deficits, particularly slow processing and memory, and attends a special school located at some distance from the family home. Mum drives him to and from school each day. Michael is dependent in some activities of daily living, but needs to be reminded to do tasks every day. Michael has applied for personal independence payment, but has received a lower rate than he was previously receiving under DLA. Wishes to appeal the decision, but doesn't know how to. If the PIP decision is upheld, then Mum will have to go out to work to make ends meet, but the family are concerned that Michael is not safe in the house alone. So let's look at Michael to begin with. So the appeal process. Before Michael can apply to the Courts and Tribunal Service, he must request a mandatory reconsideration. This gives the Department for Work and Pensions the opportunity to look at the decision again to see if it was correct in the first instance or whether they can change it. And this must be done within 1 month of the decision. Michael can request the MR in writing or over the phone. He doesn't have to put it in writing, even though the DWP will tell him he does. That's not a requirement. He can supply additional information if he thinks it will change the decision, but is not required to do so. So once the DWP has looked at the decision again, they will do one of two things. They will make a new decision. Now that decision could increase or decrease the award because it's a complete new decision. If they increase the award, any money that's owed will be paid back to Michael. If they decrease the award, they won't try to recover anything that's been overpaid. The other option is they can uphold the original decision, which what happens is 85% of the cases, the decision gets upheld. So whatever the decision, whether it's increased, decreased, or they upheld the original decision, if Michael disagrees with it, it can still appeal to the tribunal service. You can do this online now, or you can do it by downloading a claim form. The easiest way is to do it online, and it's the quickest way. It should be done within 1 month of the reconsideration, but it can be extended to 13 months, providing there's good cause. Once the appeal is accepted, Michael will be invited to attend a hearing. Now, the hearing is quite a basic and informal setting with just 3 people. So it's not like a courtroom. You just sat around a table generally with a judge, a doctor, and a layperson. And they will just simply ask Michael questions to gain an insight into his disability and how he's being affected daily. They will then make the decision and notify the DWP. So looking at the options for his parents, there are some benefits that Michael's parents can consider given their current circumstances. Carer's allowance. As Michael is in receipt of the daily living component of PIP, the parent that's not working could claim the carer's allowance for looking after him. And this can be done very simply online through the government website. To be eligible, they must meet all of that criteria. So they have to look after somebody that gets the disability benefit. It has to be for at least 35 hours a week. They must be age 16 over, not in full-time education, earn £130 a week or less. That's net. So that's after deductions and a proportion of pension contributions. And they must satisfy the UK presence and residence conditions. They can also look at universal credit. As the couple have a limited income, they can apply for universal credit. One parent is working and the other is a carer. They're not required to undertake any work-related activity. So they will just make the claim will be awarded, and that's it. It would increase their income by approximately £385 a month. So if PIP is awarded at a higher rate, either on reconsideration or at tribunal, they would then qualify for an additional premium, which would increase the universal credit to £666. Once they've been in receipt of universal credit for 9 months, they can apply for support for mortgage interest. But support for mortgage interest is a loan. So you're applying for a loan from the government to pay off the interest on a loan. And the applications for universal credit are made online. There is some help available via a telephone number, but they generally won't take the application over the phone. So anyone that can't use a computer or doesn't have access to a computer will need help. The Citizens Advice Bureau have a contract with the DWP to make new claims to universal credit. So that's case study 1. Is there any questions? I don't think there is there?
No, there is one. I have a question in relation to that, and that was, if someone's in receipt of carer's allowance, can it be transferred to another carer? So I don't know, for example, maybe that carer has now found some work, but there's another carer. Is it an easy transfer process, or do they have to reapply?
What happens is the person that's claiming the carer's allowance at the moment has to close their claim, and then a new claim has to be made by the new carer. So you can't transfer it. Much like you can't, if you have a carer that cares for one person and then changes and cares for a different person, again, it can't be transferred. You have to close the claim and then reclaim, make a new claim.
And what's the typical length of time it takes from the time that somebody fills in an application form on a site to the time that they might get some money?
At the moment, it's between 8 and 12 weeks.
Okay, so quite a lengthy time, really.
It is, but the money is backdated to the date of the claim or the date they initially became eligible, so it can be backdated for up to 3 months. So as long as there was an eligibility, as in with regards to a disability benefit, there's a possibility of getting it backdated further.
Okay, and then there's a question that's come in via the Q&A, and I think this is in relation to one of the statements you made earlier. What does a work capacity assessment involve?
There's 2 parts to the assessment. The first part is a questionnaire. So the DWP will send out a very long-winded questionnaire around somebody's capability for work, and it will be broken down into various sections. So when they score ESA and they score it on points, they have all these descriptors. So it's broken down into all kinds of different areas that people can be affected at work, and you have to score points from those descriptors. So the questionnaire asks questions about all those areas. And then there is a medical assessment. Now, it can be done in numerous ways. It can be done based upon the paperwork. So if it's quite obvious from the paperwork that this person is incapable of work, the DWP can make a decision. Or they will make either a telephone call, a video call, or a face-to-face appointment for a medical assessment that usually takes between 40 and 50 minutes. That then goes to the DWP, and the decision maker will make a decision on that.
Do you have the right to refuse a video assessment?
Yes, you can. You have the right. You can have the right to refuse any assessment, but if you refuse the assessment, you won't receive the benefit. So, but if it's easier for you to do a telephone assessment, you can even refuse the telephone assessment and ask for it to be assessed on the paperwork alone. But unless the information in the paperwork is strong enough, there's a possibility it won't be paid.
Okay.
Okay.
Thank you. Yeah.
So we'll move on to case study 2. So Eva is 17 years old with limited peripheral vision and significant hearing loss. She's not achieved much at school. Support has been minimum. She is expected to scrape a pass in English, but fail all the subjects. Eva is cognitively intact and prior to diagnosis was doing very well in school, but with visual and hearing deficits without the right kind of support has become the class clown. One parent has recently been made redundant and the family are now struggling to make ends meet. So the support from school is, we see it all too often. Okay, so we look at the options for Eva. As she's 17, she could consider an application for personal independence payment because she's now of working age due to her visual impairment and the hearing impairments. And that can be done by calling the telephone number. Again, much like the work capability assessment, there is a questionnaire to fill in and there is a medical to attend. It's important that Eva registers her visual impairment, because when the DWP make their decision, that's one of the things they look at, whether the visual impairment is, whether they are registered visually impaired. If they're not registered visually impaired, it's very simple for the DWP to decline it, to say that she isn't visually impaired because she's not registered. Should Eva decide to leave education, she will not be entitled to claim universal credit until she's 18, unless personal independence payment is in payment. Should Eva decide to remain in education, her parents can continue to receive child benefit and child tax credits if it's appropriate. She can then make a credits-only claim to New Style Employment Support Allowance. Now, although this won't pay her an income, she will receive national insurance credits that will go towards her pension. Now, they've made a change to pensions as well over the last few years. So getting the national insurance credits as early as possible is vital, because you need to make 35 years worth of national insurance contributions to gain a full state pension. If PIP is not in payment when Eva is 18, if she is not in education, she can claim universal credit, and she would be required to undertake the Youth Obligation Support Programme. Now, that's an intensive support programme based on, they say that it's based on evidence that works, and it's tailored to her needs and job goals. It is a very intensive programme that they put young people through. Options for Eva's parents. So if either decides to remain in education, the parents can continue to receive child benefit and, if appropriate, child tax credits. Universal credit, as the couple now have limited income, they could apply for universal credit. Each parent will be looked at individually, and the job centre will decide what conditionality is placed upon them in order to receive the benefit, and applications are made online. When it says each parent is looked at individually, under old legacy benefits, when one person made a claim to benefit, their partner was on the claim and didn't have to do anything. Under universal credit, each person on the claim is treated individually. Right, so case study 3. So Rishi, age 24, severely disabled with both physical and mental disabilities. He has limited capacity and relies on the use of a wheelchair to get around. As he is unable to carry out activities of daily living independently, he requires a carer to assist in most things. His parents are reaching pension age. So options for Rishi. Due to his severe mental and physical disabilities, Rishi will be entitled to personal independence payment, most probably at the enhanced rate for both daily living and mobility. That will give him an income of £156.90 per week at the current rates. If Rishi lacks the capacity to manage his own affairs, somebody could apply to the DWP to be his appointee. They can then manage all of his benefits on his behalf. So the process involves both Rishi and the appointee being interviewed by the DWP to determine A, if an appointee is required, and B, who the appointee should be. So as an appointee, Rishi's parents would be, or whoever the appointee was, would be required to comply with all benefit regulation on Rishi's behalf. Failure to do so can lead to prosecution. What that basically means is if somebody makes a claim to benefit and they don't comply with the regulations and there's something that they haven't declared, they would be liable for prosecution. As an appointee, you take on that responsibility. As Rishi is unable to work, he could apply for universal credit. He'll be required to submit fit notes from his GP until he's been assessed under the work capability assessment that we mentioned earlier. Once this has been completed, it will be determined that Rishi has either limited capability for work or limited capability for work-related activity. That basically means the limited capability for work means that he will be able to work at some point in the future, and he will be required to undertake some work-related activity, whether it's attending training courses, CV writing, that type of thing. His benefit rate will stay the same. If he is found to have limited capability for work and work-related activity, which would be likely in this case, he wouldn't be required to do anything, and he would receive an additional premium within his universal credit. Any other questions?
Yes, so we have, is an appointee the same as someone having lasting power of attorney?
An appointee is purely for DWP purposes. The lasting power of attorney covers everything, all the financial things. The appointee only covers benefits. So yeah, if you have lasting power of attorney, you don't need to be the appointee, or the DWP will automatically make you the appointee.
Okay.
Okay, and the very last one. So Penny is educated to degree level and lives on her own. She struggles to gain full-time employment due to fatigue, memory and hormone problems that impact on her ability to maintain a full-time role. She is reluctant to share her past medical history as she believes it has influenced job loss and employment in the past. Penny portrays herself excellently on paper, but this never translates into the interview scenario. She is desperate to work and be self-sufficient, but just cannot make ends meet. So options for Penny. Employees have a right within law to be treated fairly by employers. Unfortunately, it doesn't always happen. Should Penny require additional support to help her retain employment, she can apply for help through the Access to Work scheme. It can provide practical support through grants for things like sign language interpreters, lip speakers or note takers, adaptations to a vehicle, taxi fares to get to and from work if you can't use public transport, and support work or a job coach in the workplace if that's required. And also, the company will be required to make adaptations to enable her to remain in work. So there's a lot more information on the Access to Work scheme. It's a big scheme and there's a lot of help that's available. There's no real limit on the amount of money they will pay. They will pay based upon your needs, basically. As Penny is struggling financially, she could consider an application for universal credit. However, unless she is claiming as unable to work, she will be liable for conditionality. Now, this should be tailored to her health needs. This means that she'll be required to look for work and apply for any appropriate vacancies. With the job centre, it's very hit and miss as to what you're required to do, because it's at the discretion of the work coach. So Penny could have a great work coach that understands her disabilities and the problems that she's having at work, and will restrict her work search activities and accordingly. Or she could get somebody that completely ignores her disabilities and forces full conditionality on her. It's a hit and miss thing with the Department for Work and Pensions. There is a complaints procedure, obviously. Is there any questions following that?
No, so I think I was going to ask whether, if you didn't get on with your work coach, what were your options? And obviously they sound very limited in the fact that somebody's then got to process a complaint in order to get that changed.
Yes, you may be very lucky and you can just ask for a new work coach. But I worked in the job centre for 3 years and that never happened. If you were assigned a work coach, you stayed with the work coach, unless there was a threat of physical violence and things like that. But generally, you would stay with the work coach. If you made a complaint about the way the work coach was handling your case, if it was upheld, then you would be moved to a new work coach.
Yeah, I think survivors themselves have so many challenges in order to do many things. I think they do often feel quite despondent, and I've heard many stories about work coaches just not understanding, and because it's another thing on top of another thing, yes. They don't tend to challenge it too much, which is a shame, because
it is.
It could be so much different for them, and that's really what we want.
The problem with work coaches is that obviously they're not medically trained. Okay, now each job centre has a disability advisor, but getting to see the disability advisor is easier said than done. If you're in receipt of a disability benefit, it's a lot easier to be given the disability advisor. If you're not, then that's when it becomes more difficult. And the problem with brain injury clients is that because it's hidden disabilities, the DWP find it very difficult, not just job centres, but even the medical professions that they undertake the medical assessments seem to find it incredibly difficult to understand the problems that they're having, the problems that they're experiencing day to day. And that's why there is such a large amount of tribunals, PIP decisions being overturned at tribunal. It's coming down now because the DWP is supposed to be making more what they term holistic approaches to making these decisions on disability benefits, which means they should be looking at all the information that's available, including health records and everything else. That's a problem for Penny because she doesn't want to reveal that, which means when she goes for the capability assessment, if she's not revealed all that information and she comes across reasonably well at the interview, she's not going to get the benefit. And of course, the whole point of all these changes in the last 12 years is to cut the welfare benefits down as much as possible. Therefore, as much as the DWP and the government will say that there are no There are no targets in place for refusing claims. There are targets in place for refusing claims. Okay, they're just not called a target. They call them something else. Okay, in the job centre, it's called an expectation. In the medical profession, it's called something else. If a medical professional awards a lot of cases of personal independence payment, their casework is scrutinised to ensure that the rewards are correct. So there isn't the support that brain injury clients need, they're not getting, you know. And of course, a lot of them, when they receive the decision from the Department for Work and Pensions, they may request a mandatory reconsideration. But when they get the reconsideration back, they will say, well, it's now been looked at by 2 different people, therefore the decision must be right. Well, that's not necessarily the case, because both decisions have been made by the Department for Work and Pensions based upon a medical practitioner that they've employed. But they don't go any further than that. And that's an unfortunate thing. Anyone that is turned down for a disability benefit, or any benefits for that matter, should appeal to the tribunal service. If they think that decision is wrong, they should take it as far as they possibly can. And there's a huge amount of these claims that are overturned at tribunal.
And presumably, if somebody does want to appeal that process, those website addresses and you gave at the very beginning,
yes,
are they the type of people you would go to for that kind of support in doing so?
Yes, you can. The Citizens Advice Bureau are very good at doing benefit appeals, because they do a large amount of them. The problem with the Citizens Advice Bureau, like everywhere else, is that they've had a lot of funding cuts. So, you know, 20 years ago, the support that you could get through the CAB, where there was a lot more CAB offices open, they were open for longer, there was more appointments. Some of that's been cut down, but they are still there and they are still available. And there is still online help. So the Child Poverty Action Group and things like that, they have a telephone number, a helpline. So if you need advice, you can call their helpline.
Presumably there are a lot of people like the company you work for that can support these type of things as well.
There are, to a certain extent. A lot of the housing associations have welfare benefits advisors, but the help isn't available, isn't there as much as you think it would be. Okay, there's no help available from the job centres or anything like that anymore. So you're relying on, I mean, the company I work for is a private company. You know, I do some free of charge work, but generally it's a private company that charge for their services.
Yeah.
There are organisations that don't charge, and the first port of call would be the local housing association or the council.
Easier said than done, isn't it, though, getting through to people like that?
It is. It is. It is the same with all these. Probably a lot easier to get through to the local authority than it is to get through to the DWP.
Yeah, yeah. Although I must say, from my the other role, many people within Success will know I'm also a clinical nurse specialist for an NHS trust, and I have noticed in more so this year and last year than previously, I am getting a lot more calls from the DWP asking a lot more questions about claims forms that have been submitted. So I think that is a positive turn, because we can give a lot more information. There are standard questions like, can a person use a knife and fork, for example? But it does allow us not to give just that standard answer of yes or no. We can go into a bit more about that patient and what their problems might be, because sometimes there are people that can have a problem one day but not the other, just due to fatigue, for example. So it allows us to put the point across a little bit better, I think, than sometimes can just be on a standard yes or no question on a form.
The problem with all these decisions are the discretionary. So the decision maker, they're making a discretionary decision based upon the information they've got, but they're following guidance. So if the guidance is restrictive, the decision will be the same, which is why there's so many court cases, so much case law around personal independence payment and DLA and all that. There's case law where the DWP made a decision that's been upheld by the tribunal service. It's then gone to the second tier tribunal service, who've decided that no, there's an error in the law here. The legislation and the guidance is not correct. So there is helpful case law as well.
So I guess the overall messages that certainly I'm hearing are that it's always a positive thing to declare a disability, because it can help you in the long run gain more support, whether that's from a benefit perspective or from support at university, for example, in completion of coursework, essays, exams, all of those type of things.
Yeah, that's right. That's exactly right.
It's just the stigma that's associated with that we kind of need to get.
Yeah, and I mean that is that isn't a problem, and of course a lot of people with a disability don't recognize the disability, you know, which is quite understandable. So it's a lot more difficult to obtain the correct information from those people.
Yeah. I'd also like to add that obviously at Success we have a nurse advocacy service that can help support the application process if needed as well. But many survivors will have links at their hospital, whether that's their consultant or a clinical nurse specialist that can also help with writing support letters that can go alongside any application forms that are filled out as well. So it's always worth considering and asking them for help as well. I was just thinking, are you aware of any sort of pending legislation that is coming up that might impact us even more?
At the moment, everything's on hold at the moment, so there's nothing coming through imminently. There are small changes being made all the time, some of which you're not even aware of because they're coming under the radar. The last change for disabled students was brought in under the radar, and nobody really knew about it until it came in. So at the moment, there's nothing, you know, that's going to be a game changer as such. Universal migration is back on the, you know, the boiling point now, so that everyone's going to be transferred onto universal credit within the next 2 years, they think. So it's hard to say. There's nothing now, but that doesn't mean there won't be anything in 3 months' time.
And how do you keep track of those type of under the radar things?
You can, there's the government, all legislation is published. So, but it's a minefield finding and going through the legislation. There are some, there's support for welfare benefits advisors online and support organizations. There's, you know, RightsNet, which is an online community that gives you updates on all legislation changes, as well as very helpful forums and things like that for benefits advisors. So there are ways of finding out the information without having to spend hours and hours trawling the internet.
And just one more question, I promise.
Okay.
What can we do as an organisation to change the landscape of the future for beneficiaries and their rights under or rights to benefits?
Petition the government. That's all we can do, you know. And anything that we think is wrong, where we think, you know, this is basically wrong, what the government are doing, is to undertake judicial review and take them to court to get a definitive answer of whether this is right or wrong. Judicial reviews go on all the time. You know, you don't hear about a lot of them. There's some quite some solicitors that do a lot of judicial reviews for their clients and things like that. It's an expensive process, judicial review. So the more support you get through charities and things like that, the better. But taking somebody to court is an expensive process. It's simple as that. But there are all kinds of, the Child Poverty Action Group do a lot of judicial reviews. They also have preemptive letters, which basically you can use the letters to warn the DWP that you are considering judicial review. And they can be very effective in getting the DWP to change a decision under threat of judicial review. Doesn't mean you will take the judicial review if it's not changed, but just the threat of it can make them change the decision.
And would you, if somebody was going to do that, is that better to do at the point of appeal, or is it better to wait until that decision has been made and then sort of go down that route?
Yeah, and wait for the decision. If it's an appealable, not all decisions are appealable, but if it's an appealable decision, wait for that decision to be made, because it could be made in your favour anyway.
Okay. Obviously, we don't want to do anything that would disadvantage anybody.
Yes, yes.
Yeah, okay.